Stormy weather, we continue to look into who pays for fallen trees.
Well, our first report in May generated a lot of emails and calls about what your rights are as a homeowner. Well, 10 on your side, Andy Fox is here now to clarify the law. Andy.
Yeah, Alvina and Tom, our report brought to light a relatively unknown Supreme Court of Virginia case that found the owner of the tree could be responsible for all the damage, his property and the other property. That is a huge divide from what is accepted and believed in the home insurance business. This tree, guarded by the pit bulls, sits on a neighbor's lawn. During the May 24th severe storms, these huge branches broke off that tree, landing on Jean Kaufman's roof. She took these pictures, then she called the owner of the property, who owns the tree, and got the standard line.
He had called State Farm, and they said the same thing, that the tree was on his property and that it was considered an act of God.
That response, act of God, is a long-standing policy in the insurance world. Insurance agent Megan Parody.
If the tree was healthy, it's live, it's been taken care of, there's no negligence on the part of the homeowner, I don't see how you can hold the homeowner responsible.
That is not the interpretation that attorney Steve Heretic has.
Held that as a property owner, we have the right to expect our neighbors to remove nuisances, which is legally what this is.
Citing Fancher versus Fagella, Supreme Court of Virginia 2007, encroaching trees and plants may be regarded as a nuisance when they cause actual harm or danger of actual harm. The owner of the tree may be held responsible for harm caused to neighbors' property. The insurance industry points to the words may be. However, encroaching trees and plants may be regarded as a nuisance.
So you would actually have to sue.
Maybe. That would mean a judge would have to determine whether or not that tree was considered a nuisance.
But this tree that fell during the storm could now be considered a nuisance. And in our sue-happy society, this issue could end up back in court. And for the insurance industry, the court case is far too vague. Are you concerned that the word negligence is never mentioned in this lawsuit?
Very much.
Are you concerned that the word encroaching is not further defined as live or dead tree encroaching?
Yes, but I'm glad that the word may be is in there because that leaves it into the hands of the judge to make that determination.
Now, if you think your neighbor has a dead tree or a tree that threatens your property, you must notify him in writing of your concerns. If the tree falls after that, then he could be found negligent that he did not perform proper maintenance to his property. Let him know. Say, I don't like this tree. Let him know that. And therefore, he is responsible for all repairs to your property. Possibly could be. I'm Andy Fox, 10 on your side.